ready when you are.
May it please the court. My name is Michael Labby and I represent the appellant McNulty Lofts Condominium Association, Inc. At this time, I'd like to request to reserve 5 minutes of my argument for rebuttal.
Thank you.
The appellant is here today requesting that you reverse the trial court's entry of summary judgment on a claim for ejectment filed by the appellee WRH McNulty Garage, LLC. This case concerns a 13-story building located in downtown St. Petersburg, which was developed by non-party McNulty Properties, LLC. The 13 stories are divided where the first floor through a portion of the sixth is a public parking garage, which is owned by the appellee, and another portion of the sixth floor up through the top 13th floor are residential condominium units, as well as associated common elements, including owner parking owned by the appellant association. Somewhere on that sixth floor, which is a garage floor, lies the boundary between the appellant and the appellee's properties. And somewhere on that sixth floor is an access gate that if you're traveling up to the condominium parking, you would have to pass through in order to access the association's property. Page 286 of the appendix to appellant's initial brief contains a visual depiction of the sixth floor of the garage. And that depiction is oriented such that the top of the page is north and the bottom of the page is south. The order here under review found three important things. First, that the access gate itself is located on the appellee's side of the boundary line. I apologize. Second, it found that the access gate's location does not allow the appellee to, quote, fully utilize its property. And third, the relief that was ordered was for the appellant to, at its sole cost and expense, physically remove the gate and to place the appellee back in possession of its full property. The order under review does not ever specifically define what boundaries of the appellee's property are being restored to it. It doesn't identify the precise location of the boundary line, nor does it identify the precise location of the gate.
Was there a quiet title claim?
There was not a quiet title claim here. This was merely an ejectment action.
So, I mean, it seemed to me, if I recall, what the court did is it found that the condo docs adequately described the boundary.
Correct. The trial court did accept that, and that is our first of three issues forming a basis for reversal. Is our contention, as argued in the brief, that the condominium declaration was internally inconsistent as to its description of the property.
But didn't the association in their response to WRH's letter regarding the boundary, didn't they necessarily concede that based on the declarations that the boundary was impeding, encroaching on WRH's property?
I don't know that that issue would be dispositive. They did seem to address that. They weren't represented by counsel. I don't believe that was an attorney.
Does that really matter?
Well, I think it does matter if you look at the declaration itself, and it does establish an inconsistency that perhaps they weren't aware of. And what they did cite throughout the lower court proceedings was that the predecessors in interest to WRH Garage, the appellee, had always treated the access gate.
And I think their focus was more or less on an intent of what it was. So this was my big question in regard to the boundary dispute was, did anyone look at the legal description, or is everyone just looking at the diagram?
Everyone appears to be looking at the diagram. There was no witness who was competent to testify as to an interpretation of a meets and bounds description.
Is there a meets and bounds? Is there legal?
There are meets and bounds descriptions contained in the original declaration and every amendment thereto.
And so what prevails? A sketch or a legal description?
Well, I arguably, I don't think either of them prevail because there's also a conflict created by the definition of what a condominium elevator is, which describes the two south elevators at the bottom of the page, which are outside of the association's property as depicted in the drawing. But they're
the declarations, by the definitions and how they describe it, but would that prevail over the legal description?
I think at that point,
Inconsistency?
I think at that point, we need to take parole evidence and have a jury resolve that inconsistency. The point I'm making is that
Because you're saying you don't know if the error is in the description of the declarations or if the error is in the legal description. Is that
Correct. All of them are contained in the declaration, but we don't know which one prevails. And I think the best way to do that would have been to have a jury, not the trial court at summary judgment, consider parole evidence. Specifically, it would have been good to have testimony from the original developer who developed the entire building as one and then sold off the,
But we don't even know whether the legal description supports one or the other's view, because nobody had a surveyor, right?
which I think is all the more, yes, Your Honor, which I think is all the more reason. There was a survey, to be clear, but no surveyor.
Okay, but everyone certainly would have had an opportunity to do that before summary judgment.
Correct, but if everyone has the opportunity to put forward evidence before summary judgment and everyone fails, I don't think that it would be appropriate to grant summary judgment in this case.
Did Mr. Withers was there any evidence that he had any sort of surveying background or?
Absolutely not, and we identified that in our brief. His affidavit merely describes his role as the executive vice president of the appellee, which is the owner of the garage.
You did so in your brief. Tell me if that argument and objection was made at the trial level of summary judgment.
That argument was not made. The argument about the inconsistency, to be clear, I was prepared for a preservation issue here, so the inconsistency internal in the declaration itself was not specifically argued at the summary judgment hearing or in opposition. However, it was argued specifically and at length in a motion for reconsideration. This is a bit of a thorny issue because it's an interlocutory summary judgment since it placed the appellee in immediate possession of certain real property. And there's case law from the second DCA, Cagwin versus Thrifty Rents, a 2017 case that says if it's a final appeal and you raise an issue for the first time in a motion for rehearing, you've preserved it for appeal. There is no case law that really talks about it that I'm aware of on a motion for reconsideration of an interlocutory order, but I would posit that the same analysis should prevail. And if you file a timely motion for reconsideration, there's really no time limit for motion for reconsideration to an interlocutory order, but if you specifically raise the issue, you should be able to raise it on appeal. I will concede that that motion for reconsideration did not, however, specifically raise the incompetence or the lack of competence of Mr. Withers to testify as to that. It was raised for the first time again. Going to the second issue that we have is that the appellee did not, and I think this is one of the most salient issues, did not establish, nor did the trial court find that the appellant here, the association, was actually the party who installed or owned the gate or did the acts that were actually accused of dispossessing the appellee from its property. So the order under review specifically says that what is causing the appellee to be dispossessed from its property is the presence of the gate in its current location. That is all. Not maintenance, as was discussed in the answer brief, not operating the gate, just the physical location of the gate. But there was no evidence put forward by the movement or analysis by the trial court as to who installed that gate, how long it had been there, who owns it, who's
I was a
responsible.
little confused by that argument, because what this is all about is a claim that the gate's in the wrong place and it's encroaching on someone else's property, it needs to be moved. So I don't understand why it matters who put it there.
I think it matters who is dispossessing the appellee from their property. I think the argument from the appellee's perspective is that by virtue of the gate, you're in de facto possession of everything to the north of it, whether you're using it or not. And the trial court's order doesn't find anything about the appellant actually using the gate. Those arguments were made at the trial court level, but it's not contained, there's no finding in the order under review. So who installed the gate, who dispossessed the appellee, I think is critical, especially considering the relief here was the removal of the gate at the sole expense of the defendant. I think if you're going to be ejecting someone for encroaching on your property, they need to be the correct party who's actually doing the encroachment. And that's, I think, borne out in the case law, which talks about an ejectment claim has to be, you have to prove that the defendant is the person that is dispossessing you of your property. That's not case law that is disputed in the answer brief.
And maybe I'm wrong, but I thought there was some affidavit or allegations that it was the developer who had actually put the gate. And so if the developer had done it and that gives it to the condo association, isn't that the same thing?
I'm not sure about the last point, but let me address that.
I guess once it's all built out and the developer and the structures or whatever become ownership of the HOA. So I guess my point is, isn't that the same thing?
having been put there by the HOA certainly was for the benefit of them.
I don't think so. I don't think so, Your Honor. I disagree because the developer is the predecessor entitled to both parties here. The developer owned the entire thing. It didn't deed the garage portion directly to McNulty Garage. There were a few other entities that owned it along the way. But I don't think it's fair to say that just because the developer was the predecessor to the association, that it installed the gate solely for the association's benefit. I think it's just as equally fair to say that it installed it for the benefit of the public parking garage to make sure that its tenants don't cross its boundaries and begin interfering with the association property. And all of that is contained, Your Honor, within the counter evidence, the affidavit of Gary Engel, which I believe is found at, forgive me for one moment.
Yeah, and I get, I'm looking at the Engel affidavit, maybe this is where, maybe this might help. I think it's paragraph 6, it says McNulty Properties intended the lobby, the south elevator, the adjacent security gate and fence, and all parking spaces north of the security gate and fence for the exclusive use of the residential. So what you're saying is it's the gate that, there's nothing in his affidavit that referenced that the gate was for the benefit of the HOA.
That is correct. That affidavit was put forward by the appellant, and that's the only evidence that was put forward regarding who actually installed the gate. The movement's evidence was, we don't know when the gate was installed. Their affidavit of Mr. Withers says it must have been installed after the Third Amendment, but if you look at the citation for that averment, he attaches exhibits to his affidavit which contradict that and say that the gate was installed, I believe, at an earlier date. The third issue is that the appellant adduced evidence in support of its affirmative defenses from which a jury could rule in his favor. There were several affirmative defenses, only 3 of them are contended on appeal here. They would be equitable estoppel, boundary by agreement, and boundary by acquiescence. The appellee claimed both below and here on appeal that each of those defenses are legally insufficient, and even if they were sufficient, they're only supported by the Engel affidavit, which the appellee says can't be relied upon. They are, contrary to that, all legally sufficient. Equitable estoppel, the primary argument the appellee makes is that you can't be estopped by a representation from a prior property owner. I don't believe there's any case law cited for that proposition, but it contradicts Florida Department of Transportation versus Dardashti Properties, a 4th DCA case, which expressly holds just that. In that case, the FDOT was trying to argue that it couldn't be estopped by its predecessor in title, Palm Beach County, and the appellate court said, no, of course you can. You took title to this property. It was a 50-foot strip of land in that case that an 11-foot parcel had been built on by another party based on reliances by representations made by Palm Beach County. And the appellate court said, your FDOT is stopped due to those representations. Boundary by agreement and boundary by acquiescence, the appellee takes issue with those because of the recorded declaration, and appellee argues, and the trial court accepted this argument, specifically references it both in the hearing transcript and in its order, that in the face of a recorded instrument which, quote, unequivocally identifies the boundary line, you cannot have a theory of boundary by acquiescence or boundary by agreement. There are 2 problems with that. First, going back to issue 1, I don't believe the declaration unequivocally establishes the boundary line. But even if it did, the case law is very clear that if you have a recorded document which clearly identifies the boundary line, you may still assert a theory of both boundary by agreement and boundary by acquiescence. And there's Francis v. Stubbs, a 4th DCA case, and Williams versus John Tree that both stand for that proposition. There were warranty deeds in that case that identified the boundary line, and there was an argument as to whether fences in either case actually established it if they were in a different location, and they were allowed to proceed under those theories. And specifically, Francis v. Stubbs is a case that comes later than that, which is cited also from the 4th DCA by appellee, the Tarrant case. That was decided 3 years before Francis v. Stubbs. Lastly, the factual support for those defenses, if they're deemed legally sufficient. Again, I go back to the Engel affidavit and what we were talking about. The Engel affidavit would be required to support certainly the equitable estoppel theory, because that's the only evidence put forward by the appellant below about representations made on behalf of the developer. The appellee contests our ability to rely on the Engel affidavit, calling it not competent evidence and worthless because purportedly Mr. Engel didn't sufficiently articulate his relationship to the developer. But Mr. Engel, what he did testify to in his affidavit is that the developer, unsurprisingly, was a single-purpose entity that has since been dissolved, and he was.
You're at 15, just so you know. It's your time though, so do whatever you want.
Thank you, Judge Morris. I'll wrap this point up very quickly. He was an investor in the parent company, and all three entities have since dissolved. We contend that that's sufficient. And as for the other two defenses, they can be supported without the Engel affidavit, merely relying on the statements contained in Brenda Morris, the president of the Appellant Association. Thank you.
Okay, we'll have 4.5 minutes when you come back.
Thank you.
Just a short one. May it please the court, my name is Marie Tomasi. I'm from the law firm of Trum, Kemper, Bergen, Frye, O'Neill, and Mullis, and I'm here on behalf of WRH for shorthand, if you don't mind.
I guess the first question that comes to my mind, this was summary judgment. And, I mean, would a reasonable fact finder return a verdict differently?
No, and that's exactly what the trial judge found, so there was no evidence presented by the appellant that would suffice to allow it to even survive to a jury, because the evidence was pretty overwhelming in favor of our client on summary judgment. For example, this idea that there was an internal inconsistency in the declaration is there's zero evidence submitted by the appellant on that point. It's just argument of counsel. Instead, Mr. Withers testifies or attests in his affidavit, and I would say to the court, if you want to just get the flavor of what he's saying, he starts this section around paragraph 13, goes through to 21, where he says essentially, I've looked at all these documents. I've also inspected the property in person, and it's all consistent except that it shows an encroachment. He didn't have any trouble understanding the documents. The documents have both means and bounds, or just, I personally would read them, call them verbal descriptions of the boundary, but also diagrams.
So they relying, are both sides just to pose the same question to you? They're just relying on the diagrams and the declarations, the amendments and the attachments, right? No one's going out there and doing a legal description survey, right?
Well, Your Honor, there's already a condominium plat and a condominium survey and the declaration. So those three documents are all filed in the newest versions are the ones that are discussed in Mr. Withers' affidavit.
And so what you're saying is he relied on the plat and the diagrams in the plat, and he was allowed to. So when they argue his competency to do that, was he competent to do that?
I think it would be more accurate to say, and excuse me for saying it that way, Your Honor, but that he looked at all of the documents. So he looked at the survey, he looked at the plat, he looked at the amended declaration. There were 3 amendments, but the third is the most current. So I don't think it's right to say that he needed maybe a special degree. If you're in this line of work, presumably you have some understanding of these
And was that
documents.
developed in his affidavit? Other than he's the owner of the property?
Only that he is the executive vice president of WRH, and what the business of WRH was included acquisition of property.
Sure.
Maybe the president of the company doesn't necessarily have some of the, maybe experience in accounting if they were to do an accounting affidavit, but
I'm curious of the connection and.
Sure. I understand. I think your question is, could they have, and yes, sure, they could have gone out and gotten some kind of survey or additional to what was already in the record. But the thing is, everything in the record was consistent with each other. All and this is in those paragraphs of the affidavit. The description of the boundary is consistent in all those recorded documents. So aren't we supposed to be allowed to rely on recorded documents? And if you want to contest them, you need more than your argument of counsel, which is what they brought to court to contest and say there's some internal inconsistency. There's not. They just put the gate in the wrong place. Whoever put the gate, put it on the wrong part of the
I
property.
don't think the declaration says speak to the gate. I think the reference was to the elevator.
There are references to the elevator, but also, and most importantly, to the boundary line. But the elevators are not an issue in this order. So just to be clear. Okay, so Mr. Withers also personally inspected the property and he made his affidavit. There's nothing to contradict it other than counsel's argument, no evidence was offered. And so we say, if Mr. Withers is telling you that all the recorded documents are consistent with each other and are consistent with what you see when you go out there and look at it, is anything more really required when there's no contrary evidence being produced to defeat summary judgment?
What about the Withers affidavit?
I'm sorry,
The Withers affidavit?
that's what I was talking about.
Oh, okay, I'm sorry, I
Did
misunderstood.
I say I'm sorry, I might have misspoken, because I was thinking ahead to the next one, which is the question about well, actually, I guess
Is
it's.
there a conflict between the affidavits here on the sides?
Well, no, Mr. Engel has offered us an affidavit that the appellant actually titled as the affidavit of the developer and used the developer's name. But when you read the affidavit, Mr. Engel had no connection.
That's credibility, right? That's credibility.
This is, if you take a look at this court's case, in fact, I think you might have been on that opinion, Your Honor, in the Advantic case. And a trial judge does not have to accept or rely on an insufficient affidavit.
How is this legally insufficient? It was sworn to, right? He claimed that he had sufficient knowledge to be able to render the facts in the affidavit. You challenged that, and I hear you. But maybe that's something that needs to get brought up in deposition and cross-examination rather than on the face of the affidavit itself.
Well, Your Honor, in the Advantic case, out of this court in 2021, the court said that the affidavit was insufficient because the applicant failed to state how his alleged role, would have, in the party that he purported to be speaking for, would have given him access and knowledge of facts that would be admissible. Well,
He's an
Mr.
investor.
In a company twice removed.
So, I mean, I'm sorry, I can't divorce the fact that I used to do some development work and litigation. And the fact that it's twice removed, or that it was just simply an investment entity, doesn't impress me particularly much. He very well could have been the bird dog of this whole thing. He could have been the numbers guy for all we know, but that hasn't been developed. We know he was an investor, we know he had some connection. And he at least claims or testifies that he can make this affidavit.
I don't think you, Your Honor, I don't, with all due respect, think you know he was an investor in this particular building. Our argument that the developer was a single entity,
Single purpose entity.
single purpose entity is also nowhere in the
I
evidence.
mean, if we're looking at the two affidavits,
they're both looking at the declarations and they're looking at the plat. So, I mean, really just,
they're doing the same thing.
other than
Mr. Engel might have some additional background information because he was an investor during the period of time.
Okay, but Your Honor, he was not an investor in the developer. And this is why I think it's really critical to read the Engel affidavit critically, because he says he was an investor in a company called Echelon. Echelon was the parent of another company called something else. And then, so there was a subsidiary, and that subsidiary had as its subsidiary the developer here. So being an investor in Echelon doesn't really mean that you know anything at all about the developer. And isn't a sufficient legally competent affidavit required to state the basis on which you have knowledge? Yes, which is why Mr. Withers' affidavit says, here's what I did, I'm authorized by my company to make this affidavit, here's what I did to make it. You know, these records I personally inspected, et cetera, so that you know where he got his information from. So here you have instead Mr. Engel, who doesn't do any of that, and then tries to tell us what the developer intended, which I think is really quite a stretch, because he's never told us anywhere in this affidavit how he would have knowledge of the developer's intentions.
I think this is distinguishable from the Advanta case. I mean, at least from the facts that were reported in Advanta, there was literally no connection between the affiant and I think it was FTE, or I forget the name of the company. There's nothing, it's just who is this person? Whereas here, we do have some statement. We have the statement as investor, but I hear your.
I'm just saying, Your Honor, this would be, and I know I'm gonna get myself in trouble with the hypothetical, but I have stock in companies, you know, in my 401k. Can I just throw an affidavit into one of their lawsuits and say I'm an investor in the XYZ company? And by the way, here's some things I'd like to tell you, and you have to accept that without me explaining why I'm competent to know that about one of my 20 companies. And just totally need all that out. I don't actually have 20 companies in my 401k. So I'm gonna move on because you've told me, you understand what I'm saying, you might not agree with me, but the question about whether we needed to come up with evidence about who installed the gate is a red herring. It doesn't matter. If you look at the Royal Oaks case, which is cited in our brief, an action for ejectment is just to recover your own property from someone who is, as they put it, possessing it in hostility. So they even argue that the gate should be theirs, and we're saying, no, it's on our property, and we want it back, and they're saying, well, you're not getting it back. So clearly, the action for ejectment did not require us to say who installed the gate. If that's relevant to something for either side, then
What about the defense of boundary by agreement or boundary by acquiescence?
so that
One
is,
was letter.
yeah, the Tarrant case I thought was particularly.
Well, I read the Tarrant case. Here's the thing, what precipitated the litigation in that case was one side actually got an appraisal that showed them where that offense was encroaching. The other side then got a survey that showed them, and that precipitated the litigation, which to my mind seems a little bit different than what we have going on here, where it's basically folks are just kind of walking around and looking at the, like you said, looking at the diagram and saying, no, this doesn't look like the walls here.
Well, okay, but Your Honor, you have to have, for either of those, by agreement or acquiescence, you have to show that there's some kind of mutual confusion or mutual lack of understanding that led the parties to.
And that's what I suggest distinguishes Tarrant, is that when, you know, one side gets an appraisal and the other side actually gets a survey that shows them, hey, this looks like it's in the wrong place.
Well, what do our recorded documents do? Do they mean nothing that they're recorded
I don't
documents?
know, apparently there's some dispute about how you construe them.
No, Your Honor, there's not a dispute of fact about how you construe them. There's a lawyer's argument.
Let me ask you this, let's hypothetically, what if,
there is an inconsistency in the diagram of the plat or the declaration attachment diagram and the legal description? Does the law guide us in which one prevails?
I don't know the answer to that, Your Honor, to be perfectly honest, because I've not had to look it up, because I'm told there is no inconsistency. I look at it on paper, it doesn't read inconsistent to me. I mean, they're just words on paper, you can kind of lay them down next to each other. But if the, ultimately, I think if someone
so
were.
just so I understand, so what you're saying is the legal description from the beginning has consistently been the same as to the parking garage 6?
Mine is, I'm sorry, I meant to refer to the latest, the third amendment to the,
The picture's been the same? Or the picture and the legal description have been the same?
I think the pictures in the legal description have been the same, but I have to say, I did not go all the way back to the beginning, to the first amendment to look at that. But Mr. Withers testifies for affairs in his affidavit that they're consistent. And I think if somebody thought that there was something wrong with the recorded legal document, one remedy is, of course, to seek reformation. And so instead of, they just argue that. So, you know, we go to court, we present the evidence in the right form to support our claims. The judge says, gosh, I've got all this evidence that shows that it's on the property of WRH and not the property of the association, and the association won't give it back. So it's time for ejectment. And when you're the person who's holding out, you gotta pay for it. So that's how we got to where we are. And if there was a time to produce evidence of these things that counsel argues, it was before the summary judgment hearing, not here on appeal. So we would submit that if you look at the evidence that the trial judge actually had before it, that this is the right outcome, that there was no evidence of an internal inconsistency, that the Withers affidavit supported where the boundary line was. And once you know where the boundary line was, all you have to do is look at where the gate is, and the gate's either on our property, WRH's property, or it's on the association's property. So it was not a very difficult set of facts. And then the rest of the arguments are legal arguments, really about what evidence was there, if any, and is it competent? I will stand by my arguments about that Engel affidavit all day long, because we have no basis reading that affidavit to know where his facts come from or what basis he had for them. When you're two entities removed for reliance under alleged affidavit, and he does not say he has the authority to speak for the developer. The Smith affidavit doesn't tell us much at all, except for one thing, which is that the gate was used by the condominium residents. I think they like it. It's a good security feature, right? But that's me speculating. The Smith affidavit says in paragraph 6 that they used it. And I only raised that because I think counsel was talking about whether there was any evidence of that when he was discussing who might have installed the gate. So we would ask the court to affirm. We think that our outcome was well supported, and to remand us back to let us wrap up this case, since it's still an interlocutory appeal. Thank you.
Thank you.
May it please the court. Judge Morris, just to address a concern you had earlier about the identity of the installer and why that's important, I think if this order, like a standard order in ejectment action, said, here are the boundaries of the appellee's property, now you appellant leave, then it wouldn't be material to install the gate. But this order doesn't say that. Instead, it says, appellant, come onto my property, tear down this gate, and do so at your sole expense, and do it within 60 days. That's why I believe the identity of the gate installer is important. I believe Judge Smith raised the issue about problems with the affidavit being similar, and I think that's exactly right. Any deficiencies in the Engel affidavit are the exact same deficiencies present in the affidavit put forward by the movement below at summary judgment. But moreover, there were no alleged deficiencies argued below in the Engel affidavit. It came in without objection, and the trial court said he construed the Engel affidavit, but based on a misunderstanding of the case law, an understanding that you can't have boundary by agreement or boundary by acquiescence in the face of a reported instrument, the trial court dismissed the Engel affidavit as not being sufficient to support those defenses. As it pertains to internal inconsistencies within the declaration itself, there was a suggestion that that's merely argument of counsel and is not worth its weight. But of course it's argument of counsel. The inconsistency is evident on the face of the evidence put forward by the movement. The suggestion that I need an affidavit from a lay witness interpreting a recorded instrument and saying it appears to be in conflict is of no avail. That's not what's necessary. If you put forward evidence as the movement and that evidence is itself inconsistent, the case law that we cited in our reply brief is clear that that precludes summary judgment, and it's not something the trial judge can resolve. A recorded declaration is akin to a contract, and when there's an ambiguity here, and that ambiguity is present not between the drawing
Is
and
that
the...
argument made below that there's an ambiguity and we need to bring parallel evidence?
That argument was not made. The argument, nor was the argument about the internal inconsistency, except on the motion for rehearing, which was filed, I'm sorry, the motion for reconsideration, which I understand, Judge Lucas, you may not feel has preserved the issue sufficiently, but what would happen here, if the second DCA says that a motion for rehearing is enough to raise an issue for the first time and preserve it, here, if you were to affirm and this goes back down, and I take another appeal at the end of the case, there's going to be an argument that law of the case has been established and you can't address this argument again. And the Stretz...
One appeal at a time.
Well, I'm just concerned because the Stratsula case from the Florida Supreme Court, which the second DCS cited, would say that you'd have the ability to recede from that if you found that it was later preserved.
Can you answer the question for me? Are the diagrams from the initial declarations moving forward with all the amendments and the legal descriptions the same?
No, the diagrams do stay the same. The legal description changes, albeit I don't think it...
As to the parking garage 6?
It does change as to parking garage 6, but not in a way that would affect the boundary line here. The meets and bounds changes to include the building envelope, but it still does not account for the fact that the southern elevators are defined to be within condominium property, despite, if you look at them on the drawing, being on the boundary line side belonging to the Abilene. As I was going to distinguish the Adventa case, but I think Judge Lucas, you've already addressed that. For all those reasons, I think that we should reverse the summary judgment ruling in this case and allow the facts to be further developed and allow, if appropriate, a trier of fact, the jury to resolve any inconsistencies in the competing evidence. Thank you.
Thank you both. Interesting case. You guys did a great job briefing and arguing. We gotta now go sort it out.
All rise.